It is now a great pleasure welcoming Professor Reinhard Bork. Professor Bork was professor in Hamburg, and he had the chair for general and civil procedure law from 1990 to 2022. Now he is senior research fellow and at the Commercial Law Center at Harris Manchester College at Oxford, and he is also visiting professor at Radboud University in Nijmegen in the Netherlands. He is one of the leading insolvency law scholars in the world, amongst other things, and has received multiple awards, amongst them both academic and teaching awards, which is quite impressive because many scholars either are good at one or the other, but you are good at both. He has published widely on insolvency law, both in German and English languages. More recently, actually, it seems in terms of books, more in English language. And among these books are a recently issued second edition of European Cross-Border Insolvency Law, published by Oxford University Press, Principles of Cross-Border Insolvency Law, Inter Sensia 2017, a book on Corporate Insolvency Law 2020, and, of course, most importantly for us and our topic today, a book on Harmonization of Transactions Avoidance Laws, published in 2022. Professor Bork, together with Professor Weder from the Netherlands, has been very influential on recent reform attempts in the European Union concerning transactions avoidance law. And that is why it's a particular pleasure having you here today, because what we'll see and what Professor Bork will introduce is both the content, that is, how can we improve transactions avoidance law, but also I think we'll talk a bit about the processes and reform considerations. So that is, if we as scholars want to influence the lawmaking process, how can we do so? And what are the challenges that we need to consider? Professor Bork will first give a presentation, and then I'd ask you to hold your questions and comments until after the presentation. But there will be enough room for questions and comments. So Professor Bork, thank you very much again for making your way to us. We are very grateful having you here today, and I'm very much looking forward to you presenting on harmonization of transactions avoidance law. Thank you very much.
Yeah, thank you, Felix, for this very kind introduction, and good morning, ladies and gentlemen. I'm very glad and proud to be again invited to give a lecture to this course. I think the last time I was here was 5 years ago or 6 years ago. And it's always a pleasure, especially the discussion after the lecture. So for reasons which are connected with the video, I have to present first my talk and then we start with discussion, but please feel free to ask me as much as you want, and I hope I can answer all your questions. What I want to do is, on first sight, a bit surprising. I want to introduce a research project. A research project I have conducted together with my colleague Michael Feder from the Radboud University in Nijmegen in the Netherlands. A research project that ended in a book Felix just mentioned, the book on harmonization of transactions avoidance law. And to our great pleasure, the model law, which is the essence of this book, has been adopted by the European Commission in their proposal for a harmonized insolvency law in the European Union. And I think this outcome, this practical outcome, is worth to take a look at the beginnings. How did we come to a model law of transactions avoidance law? So in my talk, I will explain the project's aim, which cannot be done without some words on the need for harmonization. Then I will introduce the research project on harmonization in more detail, especially our methodological approach, the principle-based approach. I will inform you about some fundamental decisions we have made in this project and the challenges we had to overcome. I will present some of the details, not all, it's not possible in 50 minutes, but some of the details of our model law and the EC's harmonization proposals. And since I learned from Felix Steffek that you have dealt with English transactions avoidance law in the last week or last lesson, I will add some comparison of this EU proposal and English law. So let's start with our research project. What was the aim of this project? Well, the aim was to elaborate a proposal for harmonizing transactions avoidance laws in the EU member states. We were eager to find a set of rules or to develop a set of rules which should be implemented in all national insolvency laws. And why did we do that? Because we felt that we need legal certainty as to which transactions should or should not be challengeable in all member states under the same conditions. When dealing with the harmonization of transactions avoidance laws, I think the first question to be answered is there any need for harmonization? Why is it necessary to deal with this topic? And the answer is that transactions avoidance laws in Europe, and I include the UK, are very diverse. First, as regards intensity. For example, in France, there are only 4 articles on transactions avoidance. In Poland, we have 12. In Germany, we have 19. So you see the depth of regulation is very difficult or diverse, and that is also true for the details. For example, I think you have learned that for challenging preferences, there is a suspect period during which the transaction must be performed the IP wants to challenge. And the suspect period, for example, in Germany is 3 months, in Lithuania it's 3 years, and in the Netherlands there's no suspect period at all. So that is as diverse as can be. And this diversity of transactions avoidance laws hampers cross-border business, insolvency proceedings and restructuring, at least because it is necessary to find out which law is applicable, what are the special rules in another country, meaning not the country where insolvency proceedings have been opened, but a third country. And that is time-consuming, it is expensive, and it leads to a lot of legal uncertainty. We have a special rule in the European Insolvency Regulation, Article 16. I think you will deal with that today in the second lesson or next week, which assigns the transactions avoidance law in principle to the law of the state where insolvency proceedings have been opened, the so-called lex fori concursus. But then the opponent of the transactions avoidance law, I will refer to the opponent as the person who is sued by the insolvency practitioner to give something back. The opponent may defend him or herself by showing that the transaction is subject to another law of another member state and that under this law it is not avoidable or void or there's no reason for nullity at all. And that makes the process very, very complicated, because if an insolvency practitioner tries to find out, is a certain payment to a creditor abroad, is it challengeable or not, then he or she has first to assess the lex fori concursus, which is quite easy. Every insolvency practitioner knows their local transactions avoidance law. But then it is also necessary to assess what is the transactions avoidance law of the lex causae, or the other law which is applicable to the transaction. And that, again, is time-consuming, it leads to legal uncertainty, and it is expensive. So far, we have no other elaborated proposal, and that is especially true for the UNCITRAL legislative guide. UNCITRAL has submitted proposals for a good insolvency law and has asked states to implement insolvency laws according to these proposals. But the rules on transactions avoidance law are not very detailed, not detailed enough. And so they are a step in the correct direction, but they are not a solution. And now the European Commission strives for harmonization. I will come to this later on. Just a short view on our timetable, just to give you an impression that harmonization needs time. We started with, it started with a talk I gave in Athens to insolvency lawyers from all Europe. And that was met with huge consent. So we started with establishment of a working group, one member of each member state of the European Union and of the UK. And this working group was very skilled. We had 6 judges, 15 academics, and 7 insolvency practitioners. And among them, we had 9 women, 3 women being judges at the Supreme Court of their states. So very, very skilled persons in our working group. And what did we do? We drafted a questionnaire just to find out what are the current rules in the member states. We discussed the questionnaire and collected national reports. We received 25 answers out of 28. Only Malta, Latvia, and Slovakia didn't answer, so they dropped out of our working group. But these are minor jurisdictions, not so important for our task. Then the second conference, you see there is no dot here because it was Corona, so we had to cancel the conference in Hamburg. Our draft proposal was submitted to the members in March 2020. We discussed it in a Zoom conference in April 2021. It was a 2-day Zoom conference, and I think everyone here in the lecture hall can imagine that that is a very hard-trying undertaking to have a Zoom conference over 16 hours in all. But it was very fruitful and very disciplined, so I would do that again if necessary. Hopefully, it will not be necessary again. And finally, we could send our proposal, including the model law, to the European Commission, and the book was published in 2022. For me, a very important point is the methodological approach, and I will start with highlighting what we did not do. We did not start from the national laws. I think that is very dangerous if you want seriously try to harmonize any field of law. Then you shouldn't start with national laws, because immediately you have the conflict. Everybody is saying mine's better, yours worse, and so on. And all discussion is not about an optimal law. All discussion is about the national laws existing. And that is not a good start. We did something very different. We based all our deliberations on the principles of insolvency law and principles of transactions avoidance law. Principles meaning the basic value, the tenets, I will show you a list in a second, the basic values of transactions avoidance law. And that means we had to elaborate the principles supporting and shaping transactions avoidance law. We had to identify the topics to be addressed from a principle-based perspective. For example, I think the most important principle when it comes to transactions avoidance law is the principle of protection of trust, because the opponent has received, for example, a payment, and he or she normally would legitimately expect to keep what they have received. But transactions avoidance law is about the opposite. It's about taking away what he or she has got. So the preconditions, the prerequisites under which such an avoidance is possible must be balanced against the principle of protection of trust. How far are the opponent's expectations that he or she may keep what they have received legitimate, and how far are they not legitimate? I will come back to that, but That is a very important point. And of course, these principles, there are principles speaking in favor and principles speaking against transactions avoidance. They have to be balanced and weighed. And this is all in order to find adequate solutions for every single topic. So what are these principles? There are principles supporting transactions avoidance law. First of all, the best possible satisfaction of the creditor's claims. The more money you can claw back, the more you can give to the creditors. Equal treatment of creditors is a very important principle. Insolvency proceedings are collective insolvency proceedings as opposed to individual enforcement proceedings. So the principle of collectivity has a role in this play. The fixation principle, which means the assets which are part of the insolvency estate are frozen in a certain moment. Similar to your English floating charge, there's a point of crystallization, it is called. And the same we have in insolvency proceedings. The estate is fixed at a certain point in time, typically the opening of insolvency proceedings by the court. Efficiency is a very important topic, but there are also opposing principles. I have already mentioned the principle of protection of trust, and close to that, the principle of predictability or legal certainty. For example, if I'm a bank and I intend to give a credit to a foreign debtor, and this credit is secured by a lien or by a floating charge or whatever, I, as a bank, want to be on a safe side. I want to be sure that transactions avoidance is not possible, or at least I want to be sure under which conditions it will be possible if the debtor runs into insolvency proceedings. And all transactions avoidance, as all burdening legal measures, must be proportionate. I think that goes without saying. So the fundamental decisions of our project were as follows. The first was, this is an academic and not a political exercise. And that is why we have elaborated a model law, not a draft directive. As it turned out now, that is the task of the European Commission. It's not our task as academics to draft directives. That's a more political exercise. If I say we intended to concentrate on an academic rather than a political exercise, this means we intended to find the best possible transactions avoidance law, which we can recommend to all member states of the European Union. No matter, regardless whether the politicians in these member states will accept it or not. And of course, as soon as the European Commission submitted their proposal, the discussion in all member states went high, and there were lots of arguments against our model law or against the EC proposal. But that's not my problem. My problem is I have offered, in my opinion, and I'm convinced that it's a good, well-founded opinion, I have offered together with Michael Feder and our working group a very good transactions avoidance law, and if the politicians don't want it, it's not my problem, it's their problem. You know, that's what I mean with an academic rather than a political exercise. And as I already said, we were not dealing with the advantages or disadvantages of national laws, but rather we tried to find recommendable solutions in the field of transactions avoidance laws. I think it is important to say that the proposal is restricted to transactions avoidance law. There are so many fields of insolvency law which need harmonization. We couldn't do that in the same project. It turned out that that led to a lacuna in our task, because we did not deal with the definition of insolvency. What is meant by inability to pay debts? In nearly all jurisdictions, preferences are only challengeable if the debtor was insolvent. Insolvency defined as inability to pay debts, mature debts. But there are many details which are diverse in the member states. And that is why we now reactivated our working group, and we started already a second project on what is the definition, a good recommendable definition of insolvency on a European level. And we hope to be able to submit a proposal by the end of this year. We have not addressed each and every detail as regulated in some national laws. For example, in Germany, we have a special rule for avoiding shareholder loans or payments to shareholders. We did not deal with that. Or in Poland, there's a special rule on avoiding extortionate contractual penalty, which in my view is a matter of contract law, not of insolvency law. But Polish law is different. We skipped that and said it's not important. We want to concentrate on the minimum that should be harmonized. And that is a very important keyword, minimum harmonization. Our proposal aims at rules which should at least give avoidance in all member states. And we are content if some member states offer stricter national laws, offer rules which give more transactions avoidance. And that is exactly what the European Commission now did in its proposal. They also said we just understand our proposal as a minimum harmonization. Member states which have stricter rules can lean back. There's no need to be worried. You can keep your stricter rules. Maybe you are interested in some words about the challenges. If you have a working group from 28 member states, all experts in their national transactions avoidance laws, and you have a certain idea how to proceed, my keyword is principle-based approach. So what are the challenges? The first was to get everyone involved with a methodological approach, to take the principles of transactions avoidance law as yardsticks. At the beginning, some national reporters, I remember my friend Paco García-Martín from Spain, when I introduced our principle-based approach, he said, I'm leaving the room, that's rubbish, that will never work. But at the end, he said, well, that was a very good idea because we avoided discussions about national laws and had another methodological approach. But he and all the others were asked to get involved with this methodological approach and not to discuss national laws. You see the sentence, take off your national glasses. That's the only way how harmonization can be successful. We were focusing on the proposed model law. We did not discuss each and every detail as explained earlier. But we also asked everybody who wants to discuss with us our model law, please read and understand the reasons for our proposals as laid down in the explanatory notes in the book I've mentioned at the beginning. So some remarks on our model law, the outcome of this 4-year process. I will give you some preliminary observations and will shortly discuss the general prerequisites and the avoidance grounds, not all of them, and the legal consequences. So preliminary observations. The first point, which was under strong debate within the working group, was what should be the personal scope of the model law? Should we restrict our rules on entrepreneurs as opposed to consumers? Should we concentrate on legal entities, or to say it easier, on companies, and leave aside personal insolvency? You may have learned that in the Insolvency Act 1986 in England and Wales, there are different rules for transactions avoidance for a company as opposed to consumers, or to say it in other words, in insolvencies, transactions avoidance is to some extent different from bankruptcies. But we decided to put it all in one kettle and not distinguish between various types of debtors. And the same holds true for the other side, for the opponents. We suggest to apply our rules to all types of opponents, to suppliers, to employees, to banks, to tax authorities, no privileges at all. We know that in some jurisdictions, privileges are not discussable. That holds especially true for employees, but it holds also true for tax authorities. But again, that's the decision of the politicians. We find, as in our academic proposal, that one should treat all creditors equal, banks as well as suppliers, as well as employees, as well as the state as a creditor. All creditors should be treated equal. But of course, that is not self-understood. And some remarks on the substantive scope. We were discussing for a while, should we implement restructuring proceedings and debtor in possession proceedings, which is nearly the same, or in most jurisdictions the same. Should we implement that in the scope of our project? And in this case, we decided, no, we don't do that because it would explode. It's too much. We just concentrated on normal liquidation proceedings as the archetype of insolvency proceedings. We have some paragraphs in which we have laid down that we think that our rules are also applicable in restructuring proceedings, provided they require at least likely or imminent insolvency. If there is no insolvency at all, you cannot justify transactions avoidance. That's not possible. You need some sort of insolvency. And again, you see how important it would be or will be to define what insolvency means. It starts with a financial crisis and ends with substantive insolvency like inability to pay debts, but there are various stages before, and it is discussable whether transactions avoidance law should be applied in these stages as well. I skipped that as we have skipped it in our project. So there is one rule, and I think you have already received our model law in a synopsis to the EC proposal via your, I don't know what it's called, Felix, your documents service system. So if you have it on your screens, you can read it there. We have one general rule: legal acts, including forbearance, are challengeable under certain conditions. Including forbearance, that was a point of discussion and still is in some jurisdictions, because people are, how is it possible to avoid if nothing has happened? Well, the answer is forbearance omission can have legal results. For example, the limitation period is over because you have done nothing. You have not enforced your claim in courts. You have just been silent, and after a certain period of time, in all jurisdictions, there's a limitation period, and then you can't enforce your claim anymore. So by doing nothing, you have a legal effect which is detrimental to the creditors, because the creditor said, if you would have done something, then the money would be in the estate and could be distributed to us. So omission can have legal effects. And in our opinion, it's no difference whether a debtor says, I waive a claim I have against a third party, active, or I passively, I do nothing and just wait for the limitation period to be over. The result is the same. The claim is lost for the estate, and that should be voidable. So that is the first thing: legal acts including forbearance, and they should be detrimental to the general body of creditors. If the legal act is not detrimental, then there is no need to challenge it, because the reason of transactions avoidance is to enrich the estate, to get back what is missing. And if there is no detriment, then you don't need to challenge it. I think that is the same in English law. If I remember it correctly, in the section on preferences, they said that the debtor should be, or the other part, there should be a victim. A victim means the estate has suffered something. It's detrimental to the estate. So our principle-based approach, maybe I should highlight that as well, says you can't claw back everything. There must be some protection of trust. There must be some legal certainty. And that is taken regard of by referring to the avoidance grounds. So the avoidance grounds, as you have it in English law, preferences, transactions at an undervalue, etc., etc., the avoidance grounds are the culmination of weighing and balancing the principles involved. So if I start with the preferences, I will skip transactions at an undervalue and intentionally fraudulent transactions, what is section 423 in the Insolvency Act 1986. If we start with preferences, we defined the avoidance ground for preferences, legal acts benefiting a creditor. That's the first point, benefiting a creditor. The opponent must be a creditor, otherwise you can't speak of preferences. And this creditor must be put in a better position by satisfaction, payment, collateralization, giving security, or in any other way. What could be an other way? For example, amendment of the contract. You agree on a higher interest rate. That is a preference because the creditor is better off now. He can claim a higher interest rate than he could before, and that is detrimental to the estate. So that is an example for another way of benefiting a creditor. And this is challengeable or avoidable if they were perfected within 3 months prior to the filing for the proceedings. It's the first suspect period. You know that from English law. And second, the debtor was unable to pay its mature debts at this point in time. Substantive insolvency is the reason why we challenge payments to creditors in the vicinity of insolvency proceedings. And the same holds true after the filing for the proceedings. What are we missing here? We are missing mental elements. There is no protection of expectations. It is not relevant whether the opponent had any knowledge of the debtor's substantive insolvency. So there are no mental elements, and that, I think, is debatable, because there are two forms, two variations of preferences. The first is, I pay a creditor who is entitled to this payment. We call that a congruent coverage. And in the next paragraph, you can see this definition. If a due claim of the creditor was satisfied or secured in the owed manner, congruent coverage. So the transaction that we want to avoid is a performance that the creditor was entitled to in the moment when he received the performance. That is a different thing from paying a creditor something he was not entitled to. For example, paying him or her earlier 2 months because he put a lot of pressure on the debtor and said, pay me now. I know the claim is due in 2 months, but pay me now so that I'm on the safe side. That's an incongruent coverage because the debtor was not entitled to this payment. At this point in time, he would be in 2 months, but he's not now. Or another example, the claim is directed to money and the debtor says to the creditor, I owe you money today, but I don't have money, but I have an old car, which is worth, let's say, £5,000, and I owe you £5,000. So instead of money, I offer you my car. And the creditor said, okay, I take that. That is an incongruent coverage because the creditor couldn't claim the car. He was not entitled to receive the claim before they agreed on this strange kind of satisfaction. So that is why in many jurisdictions, including France, Germany, and others, the rules are different for incongruent, for congruent coverage. And we decided in the case of incongruent coverages, this should suffice, no mental elements. But when there are congruent coverages, then, and I read it, the legal act is only voidable if the prerequisites of paragraph 1 are met, as explained, and the creditor knew or should have known the debtor's inability to pay debts or the filing for the proceedings. Mental elements, ladies and gentlemen, have to be seen very skeptically because they are difficult to prove. And to say just now, that is one of the huge disadvantages of English transactions avoidance law, because it's full of mental elements. And they are difficult to prove. And because they are difficult to prove, we inserted two helpings for the, two remedies for the insolvency practitioner. The first is we are content with gross negligent ignorance of the debtor's substantive insolvency. That is covered with the words or should have known. And we have explained in our book, or should have known means gross negligent ignorance. And second, that is the last sentence, this knowledge shall be presumed if the creditor was a party closely related to the debtor. And what you see now is that the principle of protection of trust has a different meaning because we are convinced that the expectations of the opponent to keep what they have received is less legitimate in the context of incongruent coverages than it is in the context of congruent coverages. And that is why we implemented, although hesitatingly, a mental element here. By the way, the same can be found in many, many jurisdictions. They know mental elements in the context of preferences only for congruent coverages. So it is necessary to have some exceptions. Some are symbolized by the 3 dots here. They are prescribed by European law. I will not go into detail there. But there should be an exception for legal acts performed directly against fair consideration to the benefit of the estate. Why is that? Well, the first principle which requires such an exception is the protection of the debtor. The debtor must be able to buy whatever, rolls, a beer, a burger, you name it. And that is normally the exchange of money and the product. And let's assume that the price is fair. You can dispute that for burgers, for example, but let's assume the price is fair. So the debtor would have severe problems to buy something to eat and drink if the opponent, his contractual partner, must be afraid that after some days, insolvency proceedings are open and the consideration, the price for the burger is challengeable. That shouldn't be the case. It doesn't work and it's only small money. It doesn't make sense economically, but it is also legally not wise to do that. The second case for applying this exception is much more relevant. It's the business of a company or an entrepreneur. In modern insolvency laws, it's a main target to try to rescue at least the business. And you can't rescue a business if you don't have this exception, because you must keep the business running. You must pay employees, you must pay suppliers. And if you do that against fair consideration to the benefit of the estate, because a running business is has more value than a closed down one, then that should be exempt from transactions avoidance law. That is more or less accepted in all jurisdictions. Also, for example, in the US bankruptcy code, they have the same. It's a modern and necessary exception to the transactions avoidance of preferences, not of other avoidance grounds. So I skip transactions at an undervalue due to my time restrictions and the transactions intentionally damaging creditors, and throw a short glance on the legal consequences. What are the legal consequences in transactions avoidance law? And they are very diverse in Europe as well. In some jurisdictions, the legal consequence is the transaction is void by force of law. It's null and void. The moment insolvency proceedings are opened, all these transactions are null and void. And that is a nightmare under the aspect of legal certainty, because all other people who have nothing to do with this debtor trust in the validity of the transaction. So declaring it void without any register or any objective moment indicating this voidness, that is not working. And so we decided, paragraph 2, that the opponent is obliged to compensate the estate for the detriment caused by the voidable legal act. That sounds complicated. It basically means he has to pay back what he has received, if it is about payments. But there are many, many other questions. For example, what is with, how do we deal with emoluments or fruits? Are they also to be returned, or can he or she keep it? Well, that depends on whether there's a detriment caused by the voidable legal act. And the answer is yes, because if the object would not have been transferred to the opponent, it would have the emoluments and fruits in the estate. It had enriched the estate. So that is how to correct the economic situation caused by the voidable transaction. There's another legal consequence which is very important. The legal position resulting from the voidable legal act may not be invoked against the estate. What does that mean? That means you can simply ignore the voidable transaction. Example, the insolvency practitioner claims against the opponent to return a certain object that has been transferred to the opponent. And this object has been burdened with a lien. And now the insolvency practitioner says the transfer of the object is voidable, and I want you to give it back to the estate. And the opponent claims, well, but I have a lien. So he defends him or herself with enforcing the lien. And the legal result, the legal consequence, according to Section 7, paragraph 1 of our model law, is the lien can simply be ignored. So because the lien is voidable as well, and then the result is that the opponent is not able to defend themselves with this lien. So that is another important legal consequence. So much to our model law. Now I will turn to the proposal for a directive of the European Parliament and of the Council harmonizing certain aspects of insolvency law. Certain aspect means the European Commission does not intend to harmonize insolvency laws entirely. That's not possible at this point in time. That needs more fundamental research. But they want to harmonize certain aspects. For example, a very well-known topic in England, prepack sales, or directors' duties to apply for insolvency proceedings. These are other topics, but the main topic is harmonization of transactions avoidance law. And I must admit I'm a bit proud that the EC proposal is nearly word by word the same as our suggested model law. And the reason for that is we gave our model law to the European Commission, and they gave it to an expert commission which gives counsel to the European Commission, and they saw our model law and agreed with our opinion that it can't be better done at this point in time. And they recommended to transform our model law into a directive, and that is what the European Commission did. And this synopsis shows that all our points are available nearly word by word. Some words are changed, but not the meaning of the rule, and it is has a different order from our order, but that's not of any importance because the legal outcome is nearly the same. I just want to draw your attention to the last point. As I explained, our aim was to find a minimum harmonization proposal, and that is exactly what the EC proposal claims in Article 5, not only for harmonization of transactions avoidance law, but also for other harmonization fields. The headline is something, the heading is something misleading in relationship to national provisions. That means minimum harmonization and national laws can be tougher, can be stricter. Just an example, the proposal for directors' duties to file for insolvency proceedings is 3 months after the occurrence of substantive insolvency. In Germany, it's 3 weeks or 6 weeks, depending on the ground for opening insolvency proceedings. So it's significantly shorter, but that is no problem because we have this Article 5. I will come to an end in a second, but please let me just present this synopsis of our proposals, and with our, I mean the research project and the EC proposal. As you know now, they are identical more or less. On the one hand, and the Insolvency Act 1986 on the other hand. And for time reasons, I can't explain that in much detail, but I just want to give you the results. In my opinion, and this opinion is shared by Jerry McCormack, who is an insolvency lawyer and a professor of insolvency law in Leeds University, and he was a member of our working group. And we asked him we asked all national reporters, but also Jerry McCormack, what would be the difference between the model law and your national law? And his answers, and I think he was entirely correct, is the transactions covered by the rule on preferences are the same. So it includes forbearance, it includes collateralization, and so on. But there is no distinction between congruent and incongruent coverages, which may be fine under the rule of minimum harmonization, but is debatable under a principle-based approach, because we think in the case of congruent coverages, the protection of trust should be stricter than for incongruent coverage. The suspect period is, we suggested 3 months. Here it is 6 months and 2 years for connected parties. And that is a disadvantage of English law. Please excuse me for saying that. It's just an objective remark and has nothing to do with my objections against the Brexit. It's really an academic analysis. The debtor's desire to prefer is required, and there we have a mental element. And as I said before, mental elements are difficult to prove, and they bring a lot of legal uncertainty. So we would suggest to be as careful as possible with mental elements. And the same, in the end, holds true for transactions at an undervalue. We call that, or the EC proposal calls it legal acts against no or manifestly inadequate consideration, but that's not a difference. It covers the same transactions. The suspect period is different. It's 6 months in England and 2 years for connected parties. And now again, we have a mental element, the exception where the debtor acted in good faith it is proven by the opponent. That makes it difficult for him or her to prove the mental element, but it's a mental element. In good faith and for the purpose of carrying on its business, and at the time it did so, that there were reasonable grounds for believing that the transaction would benefit the company. You have dealt with that, I guess, in your lecture here, and my task is only to point out that mental elements in this context are rare. I think there are only 2 or 3 jurisdictions in Europe, including the United Kingdom, where transactions at an undervalue is combined with a mental element. And lastly, legal acts intentionally detrimental to creditors, that is your section 423. The Actio Pauliana, you may have heard about this keyword, the Latin origins of transactions avoidance law. Transactions defrauding creditors. On the pro side, this rule does not require any insolvency, so the scope is much broader, and there's no suspect periods, which is also avoidance friendly. But, and I have never understood how that is so, it is restricted to transactions at an undervalue. I've never understood why English law does that. I have explained this rule in context of other European rules in an article. I have given you the reference here, which analyzes the decision of the English Court of Appeal in the Sequana case, which deals not only with directors' duties, but also the shift of duties that was before the Supreme Court. But the Court of Appeal also dealt with Section 423, and that the restriction to transactions at an undervalue requires a lot of hermeneutical acrobacy to find out, is there a transaction at an undervalue? And the second point is the rule requires the debtor's purpose to prejudice creditors. That is not so unique because nearly all comparable rules, including Article 8, require such a mental element. And that is because in this rule, the intent of the debtor is the reason why we challenge this. So it's the only reason for having such a rule is the intent of the debtor. So you can't do that without such an intent. Okay, ladies and gentlemen, thank you for your attention. I hope I could give you some impression of what is going on the continent. I'm not confident that English legislator will follow the European proposal in this respect. They did very efficiently with our directive on restructuring and insolvency regarding pre-insolvency restructuring frameworks. As soon as this European directive was out, the English government made a proposal for what is now the SIGA 2020, so the improvement of your schemes of arrangement and other things, the implementation of a moratorium. So sometimes English legislator is still looking to Brussels, what is happening there, and they are adopting ideas coming from the continent. But even under your new Prime Minister, I'm skeptical whether they will adopt our proposals on transactions avoidance law. Thank you very much.